Alright, we're only a few minutes in and you can already see where this is headed. The defendant is making a classic sovereign citizen argument, that the court somehow lacks authority over him because of his citizenship status and legal definitions. But here's the key question. Can a person simply declare themselves outside the court's jurisdiction? Let me know in the comments what you think before the judge answers that challenge.
Court will call People versus Robert Geese, 26T884. You'll come on up and have a seat at the table. And then I show we have Ms. Morissette and Shireman for the people. All right, so I show that we're set on for a motions hearing. I don't show that there were any motions. I believe the motions that were previously filed had to do with obtaining discovery. Is that correct, Mr. Geese?
Yes.
Okay. And how do I say your last name?
It is Geese.
Geese. Okay.
And in Canada,
Oh.
in Canada, Geese.
Okay. All right. So I have not received any endorsement of witnesses or defenses for your case. So I take that to mean that you won't be calling any witnesses other than possibly testifying yourself. Is that correct?
Your Honor, thank you, first of all. Good afternoon. I filed the motion for discovery. There are 6 points, actually 7, but 6 points within that motion that have not been answered. And I also filed an affidavit of truth, and that has not been answered. Therefore, I don't understand how the court can move forward. I do want to correct the record on a couple things, if I may. Do I have your permission to read this into the record?
So let's go back to the question that I asked first. Are you going to be calling any witnesses? Because you did not file any endorsement of witnesses.
I don't know how we can move forward calling any witnesses without answering the motion and affidavit that's before the court presently.
Okay, why don't we start then with your motion for discovery? What exactly is it that you're claiming with the motion for discovery?
Do I have standing to read this into the record, first of all?
You don't have to ask for standing, so.
Thank you. Respectfully, for and on the record, I am Robert Geese, a living man of the Union, a non-belligerent or enemy of the state, and I occupy the office of Executor and Co-Trustee for the Nole Me Concari Express Trust. I am here propria persona in that regard, not pro se, by special appearance only, not generally. Further, I'm of the age of majority by both the age.
Can I stop you for just a second? I am not going to consider claims that you're saying that I can't proceed on the case because you are not a citizen or anything like that. We're not going to proceed that way, okay? So did you say that you had some actual discovery issues that you needed to address?
Your Honor, respectfully, am I being denied my due process rights of being able to read this into the record?
You can file whatever you'd like, but no, I'm not going to sit here and listen to you just read a document into the record, okay?
I object.
Okay, that's fine. So did you have any actual discovery issues for us to address?
The discovery I filed, it's in writing. I don't know that it's necessary to sit here and read everything into the record. You just said that you don't want me reading into it, and now you're contradicting that with something else.
Any actual discovery issues? Is there some part of discovery that you believe that you have not received?
All of it. Nothing's been answered.
Okay, so this is not a situation where they have to answer questions, okay? This is not a civil case where you get to do depositions or ask interrogatories. As part of a criminal discovery, they're required to give you some documents through the case. Did you receive the discovery?
Did I receive what discovery?
Okay, have the people provided discovery to the defendants?
Sorry, double checking through the workflow, Your Honor. Yes, it has been provided.
Okay.
What did that consist of?
This is one of the most common points of confusion in these cases. The right to travel absolutely exists, but courts have repeatedly distinguished between the right to move freely and the regulation of operating a motor vehicle on public roads. Watch closely here, because the judge is about to draw a line that becomes the central issue of the entire hearing.
Can you let me know what discovery you provided?
So that would be all the evidence from the case. So that would be reports, just like criminal history. Looks like there is body-worn camera available. Basically anything in our case file that's evidentiary would be provided to you. Typically you have to go to the front desk of the DA's office and pick it up because they're a large file, so they'll burn it on a CD for you. So if you haven't picked it up already, it's probably sitting behind our front desk ready for you.
Have you picked up that documentation yet?
I've never been given any notice of anything, and
So
the question I have is this so from
discussions about how to obtain discovery from the district attorney's office?
I object. I don't understand how this court can move forward. I have been very succinct with my motion for discovery.
So
If I understand what you're saying, pardon me, may I continue? Yes?
the way that discovery works is that you are required to go pick it up from the DA's office, okay? So it is not a situation where the court is determining whether the case can proceed. This is not a felony matter where the court is having a preliminary hearing or anything like that. So you have not filed any motions other than the fact that you did not receive discovery. So you know the procedure to get the discovery. You need to go to the DA's office to obtain that.
I'm referring to my motion for discovery, my requests, demands, really. And if I may go back to something you mentioned earlier, Your Honor, respectfully again, if I could have finished what I wanted to read into the record, I come here in peace. But you mentioned that this is not civil, this is criminal. Is that correct?
That is correct.
So there's a crime committed here.
So I'm not going to have these discussions with you, okay? If you want to file a specific motion to have me rule on it, I'm happy to do so. This is not a situation, like I've said several times, where the court is making a determination about a preliminary hearing or anything like that. So you have not filed any motions other than not receiving discovery. I am not going to say that there's no jurisdiction to move forward or anything like that. That is not the situation here, okay? So at this point, you need to go get the discovery from the district attorney's office. I told you that when we set this for trial. If you decide not to do that and don't have that information, that's up to you, okay? So at this point, I'm not going to grant any of your motions because there hasn't been anything that has anything that would have anything to do with a motions hearing at this point. The court is going to deny those requests. We are set for trial readiness on July at 11 o'clock, and then we're set for jury trial on July at 8 o'clock. Trial readiness is the last date that the court will accept any plea agreements. Because you have not filed any endorsement of witnesses or defenses, then you will not be permitted to call any witnesses at trial other than possibly testifying yourself. You also would not be able to assert any affirmative defenses, but this does not appear to be the kind of case that any affirmative defenses would apply.
I object. I do not consent to this procedure.
You don't have to consent, so.
Absolutely.
I am.
And I object also the fact that I'm being denied my due process rights to read into the record, regardless of what this is.
You can
procedure is
file
called.
whatever you'd like, but I'm not going to sit here and waste court time with you reading things into the record. You can certainly file whatever you'd like, okay?
I have done that, Your Honor.
I have.
And they have not been answered.
We are not required to answer essentially interrogatories from you. That is not required. So I have denied all of your motions. So we will continue the case then to trial readiness on July at 11 o'clock.
So, if I may, Your Honor, you are denying that this court or prosecution has any need or any responsibility to answer my motion for discovery, my affidavit of truth, which are all in writing.
There is no grounds for you to file any affidavit of proof. There is no right to a preliminary hearing or anything like that in county court. So it is not a situation where the court is going to make a determination ahead of time regarding any of the facts. That would be what the jury trial is for.
In my motion, I reserve my right to a trial by jury of my peers.
It's set for a jury trial.
I don't want a jury trial. Why would I want a jury trial? I want a trial by jury of my peers.
It doesn't mean it's your friends and neighbors. It means it is a jury panel in Weld County.
Isn't that what it's supposed to mean?
I am not going to fight with you about this, okay?
I don't mean to
So
fight
the
you.
case is set for a jury
Posing
trial.
questions.
Okay, so it's time for you to go. I am not going to sit here and fight with you about any of this. All right, the case is set for a jury trial.
And now the conversation takes a dramatic turn. The prosecutor isn't arguing philosophy, she's arguing jurisdiction. Notice the difference. The court isn't asking whether Mr. Williams agrees with the law, it's asking whether the law applies to the conduct being alleged. Those are two very different legal questions, and that distinction is about to become critical.
This is in the District Court of Gove County, Kansas. It's case number 25 TR 687, State of Kansas versus Francis F. Hodge. And you are Francis Hodge?
Yes, the living man, Francis Hodge.
Okay. I have an announcement of appearances, please.
I'm sorry.
May it please the court, the state appears by Noah Haas, Assistant Gove County Attorney.
And you're Francis Hodge III?
Yes, the living man.
Okay. And Mr. Hodge, it's your desire to continue representing yourself,
Yes, sir.
and you're not requesting counsel?
Correct.
Okay.
Well, I mean, the counsel I have is just not a lawyer. That's all.
Okay. And you do understand the potential punishment for these offenses?
I do.
Okay.
According to your ways, yes.
Okay. By statute, count 2 and count 3, for which you're entitled to a jury, if convicted, you could do up to 6 months in county jail and up to $1,000 fine. Count
Yeah,
1.
that's your statutes. Yeah.
Count 1 is an infraction, a speeding infraction. That's tried to the court, not to the jury. Okay?
Okay.
And that is subject to a fine if convicted.
Okay.
Okay. Now you've requested a jury, and we've got a jury trial scheduled for Monday, June 29th in 2 weeks.
Right.
Okay, and you understand you have to be here in person in
Right.
the Gove County Courthouse.
Yes.
Okay. Currently, count 1 is charged speeding 75 and a 70. That's a traffic infraction. Count 2 is failure to provide proof of insurance, a Class B non-person misdemeanor. And count 3 is driving while revoked, a Class B non-person misdemeanor. Mr. Haas, are there any amendments to the complaint or information? I noticed you had filed an amended complaint on June 12th, 2026. It cites the exact same charges. You just put it into a little different statutory language.
Clarified the subsections, Your Honor.
Have you sent that to Mr. Hodge?
Yes, Your Honor, we did by mail.
Okay.
And I think email too.
Have you received that, Mr. Hodge?
I received it by mail. Yes.
Okay. So you're fully aware of what you're charged with, and you're not looking to amend those charges any further, Mr. Haas?
No, Your Honor.
Okay. And Mr. Haas, have you issued your subpoenas to assure the attendance of your witness?
I don't think I've done that yet, Your Honor. I have spoken with the officer. He's aware of the date. I can get that in. I can get that done today.
Okay. I'm sure you get that done.
Excuse me, Judge, and Mr. Prosecutor. Could I get your full names? I do apologize.
Yeah.
My full name is Noah Haas.
Noah Haas. Noah, Noah.
Yep.
And Haas, Haas.
Hahs. It should be spelled out on the Zoom there, too.
Did you catch that? The judge may have just exposed the biggest contradiction in the entire argument. On one hand, the defendant is relying on constitutional protections. On the other, he's claiming parts of that same constitutional framework don't apply to him. From a courtroom perspective, that's a tough position to maintain. Have you noticed the judge keeps bringing the discussion back to practical legal authority instead of abstract theory?
I'm sorry, what was it? I got two screens up. H-A, what?
H is in house, so there's two H's.
Oh, okay.
House.
H-A-H.
S.
S, okay, gotcha. And are you bonded as well? Mr. Haas?
Mr. Hodge, that's not an appropriate question at this time. Okay.
What do you mean at this time? What time will it be appropriate?
Well, he is a duly appointed assistant county attorney.
No, I understand that, and every attorney needs to be bonded just like you as a judge.
He's licensed.
No, I said bonded. I didn't ask for a license. I asked if you guys were bonded.
Well, he's licensed. He's sworn in.
Are you required by Kansas statute to be bonded to perform your duties as judicial officers?
We're required to be licensed. We're
But
required
not bonded.
to be elected and or appointed.
But not bonded is what you're saying? You're not required to be bonded?
Right.
Okay.
Okay.
And what was your full name again, Judge? I'm sorry.
Just like it says on the screen, Thomas J. Dries.
Yeah, I'm on two screens, unfortunately, on the Zoom, and I can't see that part. I'm typing on my notepad here. Can I go ahead and get your name for the record?
Yeah, Thomas J. Dries. Okay. Mr.
Right,
Hodge,
thank you.
have you sought discovery and inspection in this matter?
I'm sorry, how about what?
Have you sought discovery and inspection?
Have I sought discovery? Yeah, I'll present everything at trial.
No. Have you
I-
sought discovery from the state?
Oh, have I sought discovery? No, I don't see a point to seek it because it's already presented.
Mr. Haas, have you sent any discovery to the defendant?
Your Honor, we have not received any requests for discovery, nor have we sent any discovery materials.
Okay. And have you requested reciprocal discovery?
No, Your Honor.
Mr. Hodge, do you intend to set forth any objection to the institution of the prosecution?
Oh, of course, I do have objections, but being that we already have the trial date already in place, it wouldn't do any good to try to do anything before the trial because we're not going to get anywhere.
Okay. So you're not alleging any defects in the complaint.
I'm sorry. Can you? What is that in like plain English? Any defects and complaints? Are you saying do I disagree with any of the charges?
No, I'm saying, are you alleging that they have charged the wrong crime? Have they charged the wrong date? Have they charged the wrong jurisdiction?
Oh, the wrong crime for sure. Jurisdiction, I'm still up in the air. I'm not sure about. But yes, the wrong crime. Yes.
Okay, you don't believe you were in Gove County?
Oh, I didn't say that. You know, I mean, I got pulled over in Gove County, so we know I was in Gove County.
Okay. Are you claiming any violation to your right to speedy trial?
No, I think this is speedy. I have no complaints against that part.
Are you claiming any alibi?
There's no alibi to be had.
Okay. Are you intending to file any motions to suppress during the trial?
I won't know that until the trial.
This is the moment the hearing effectively turns. The judge has now formally ruled on jurisdiction, which means the debate is no longer about whether the court can hear the case, it's about what happens next. And here's something many people miss. Once a judge rules on a motion, repeating the same argument usually doesn't change the outcome. The legal battlefield has shifted.
It is one day. It is a 6-person jury. Each side has 3 peremptory challenges. So we will qualify 12 jurors and strike down to 6. Okay. And does either party anticipate filing any motions in limine?
And what?
Motions in limine, which is
Yeah.
a motion to limit what can be presented.
Oh, no.
Yes, Your Honor, I do intend to file a motion in limine concerning anticipated meritless legal arguments.
What does that mean?
Such as what?
Arguments that Kansas lacks jurisdiction over the defendant. Arguments about being a secured party, traveling, not driving, jury nullification. Arguments about the judge, the court, or the state being corporations. Claims that statutes only apply upon consent of the defendant.
Why would you limit that?
How long do you anticipate needing to get that on file, Mr. Haas?
Believe I could get it filed within the next couple days, Your Honor.
Okay. Can you do it by the end of the week?
Yes, Your Honor.
Okay.
Would that filing be ruled as okay to have those limits?
We'll take that up at the time of at the start of the trial. We'll take
Okay,
those
because
up.
I would need to know that before the trial. Because if those kind of limits are there, then basically it sounds like you guys would be violating my constitutional and civil rights if it's accepted.
Well, we'll take those up at 8:30 in the morning on the 29th.
Well, a part of me showing up, I could take a warrant, but I think it would be more fair if that is known ahead of time, because there won't be no sense in me playing those kind of games if I'm unable to bring the fullness of what I may bring, what I have to bring, representing myself to the table. There shouldn't be no limits. You should be able to hear everything, especially when it comes to the law.
Well, he's filing his motion by Friday at noon.
So should I file a motion to have no limit?
If you wish to file a response, You must file that by next Wednesday at noon.
Okay. All right.
I'll make sure I email you immediately after filing, so you should have enough time. As well as we'll mail it out too.
And can I also get your email so I file as well?
I have sent you some correspondences, so you might be able to find it, but it's Noah. That's Noah.
Okay. Now I'm talking about to the judge. You said you was gonna
Oh.
email the judge.
I'm going to email you the motion right after it's filed, so you have as much time as possible.
Okay, I appreciate that. But I would also like to file my motion to the judge just like you. I just
Well,
need an email if that's okay.
You'd file it with the court.
Okay, and what's the court's email? And you need that motion in by next Wednesday, you said?
Yep, by noon on the 24th.
Okay. And what is that called again? A motion of limity?
Motion in limine.
Oh, in limity. Okay, thank you.
Limine.
Line. Okay, got it. Thank you. Okay, all these extra steps is interfering with my work. So how can we limit some of these steps so I can stop missing work? Or can I just charge my time from work off to the court?
And this may be the most important legal explanation of the entire hearing. The defendant keeps citing bills of attainder, but the judge is pointing out that a bill of attainder involves punishment without a trial. Ironically, the very fact that he's being offered hearings, motions, and even a jury trial demonstrates the due process protections that courts are required to provide. At this point, the case isn't really about constitutional theory anymore, it's about whether the allegations can actually be proven in court.